Hi, everyone. Welcome back to another episode of Tax Sale Insiders. This is part two of a three-part mini-series with Randy Saunders and Matt Abey from Nelson Mullins. Welcome back, guys.
Good afternoon.
So in our last episode, we focused really more on, how how your model, depending on what your model is, how that might be better suited for one state versus another, and vice versa, and how those things are things to keep in mind as you look at a state that would certainly guide you in maybe either refining your model or choosing a state to pursue or not. I guess, and certainly Randy, Matt, jump in here to kind of correct me, but I think you used West Virginia as a good example of where you maybe, if you want real estate, West Virginia is a good example, versus Kentucky would be a state where you want real estate. It's probably not the best model, but would be for an arbitrage spread type of model. So I kind of today I want to dive a little deeper into that subject with I think there's certainly specific examples of worst case scenarios, we're calling it, of things that you come across that I think a lot of people getting into this industry don't really think about. And these are definitely some of the items you need to think, definitely keep in mind as you're looking at a state and what you should research prior to auction, et cetera. So maybe let's just dive into that a little bit. Matt, you had mentioned something about having various errors in the chain of title and how that can be a nightmare. Can you elaborate that on that a little bit?
Yeah. So one thing that we see in some of the southern states, and I've dealt with in South Carolina specifically, are heirs property issues. So this dates back traditionally in South Carolina. Some of our minority groups didn't really feel comfortable recording deeds, recording wills at the county courthouses. There was a lot of skepticism over whether or not judges and local county officials would take steps to try and take somebody's property, or they would levy it more than they would levy somebody else's property, all in the attempt to kind of slight those minority groups. So what would happen is a lot of families would not record deeds. They wouldn't record wills. They would record kind of lineage in a family Bible that was at whoever the oldest matriarch of the family might be, and they would pass down property verbally or just by letters or just generally agreements amongst the family. And what happens in that scenario is that you've got a husband and wife who own the property in the we'll call it late 1800s. Well, by the time we're here in the 1900s and 2000s, I mean, there could be 40-something heirs where this property has just devolved to each line of kin, and it just gets split into a fractional amount. And somebody's probably living at the property. It's a homestead for them, and they're paying the taxes. But then that person dies, and nobody really knows who owns the property or who's responsible for paying the taxes. So it goes to tax sale. Well, what you got when you're trying to figure that out on the back end and do a quiet title or something, one, it's more expensive because you got to serve 40-something people with process and make sure that everybody is able to come to court and has their day in court to argue that the tax sale is invalid or that you didn't get a full interest with the tax deed. But you've also got situations in South Carolina specifically where the heirs have not been researched by the county, and they're not sending notice to all the heirs. They're sending notice maybe to the one person that lives there, maybe whoever back in the last deed in the chain of title in the 1800s, they're sending it to that address, which, I mean, by that point, the property could be in a different county or a different city, or addresses have changed. And so you've got a failure of notice, and that fundamentally impacts the tax sale. And we've seen this. Lawyers always love to share war stories. We had a property down in Beaufort County that was on two sides of the road. It was one particular property, and a sister lived on one side, a brother lived on the other. But there were something like 5 more brothers and cousins who also had an interest in the property. Some were on speaking terms and were local, but others had moved to other states and hadn't been heard of or heard from by the family for years. So trying to quiet title to that kind of property was a mess. I mean, you imagine the infighting amongst family members when they find out, because they didn't know about the tax sale, but they find out from getting served with the summons and complaint that their brother Billy or whoever it is has been living at the property for 20 years when it really should have been split, 5 ways or 6 ways against all the brothers and cousins. So you can get caught in the middle of a family feud in those situations, and you can have trouble quieting the title because the tax sale probably just wasn't valid because notice wasn't given to all the heirs. So that's something that you really got to watch out. We've seen in South Carolina, but a lot of the southern states.
Now, is that something that I'm sorry, Randy?
No, I think, one of the consistent themes as we go through kind of these worst case scenarios is, I guess from our perspective, as we're looking at what kind of defines a worst case scenario, we're looking at, impact on return on investment, or actually eliminating any potential return and actually creating a loss. And when you look at the situation that Matt's talking about, that is a huge additional expenditure, of not only capital for attorneys' fees and the court, but also time. And I mean, we know one of the biggest things that you're trying to balance in this industry, the cost of capital, especially if you're having to borrow it, is significant. And the longer it takes to get that to a point where, you can monetize it, the bigger issue that is. And so, the scary thing in a situation like Matt's talking about, if a lack of due diligence leads to, a sales season where you acquire, a handful of these properties, and then you have to go through this, and so, it's you've got it, then you're kind of stuck with it. Then you look at it, and as you're deciding, what do we do now? Because there's a lot of steps that are ahead of you. There's a lot of time, and there's going to be a lot of cost. And so I think that first step in that worst case scenario, kind of, when you're trying to break down the action plan, is assuming now that we have this, if we go through all these steps, are we still going to be able to realize any profit at all? And I think that's why you really want to be able to reach out and talk to somebody like Matt who's gone through this to say, all right, as opposed to kind of the traditional action when we're dealing with these heirs properties, how much more cost are we actually expecting? How much more time are we actually expecting? And, what's best and worst case scenario on, how much this is going to impact? Because again, if you're looking at it and you've got these and you say, okay, let's say we've got 10 of them, and you just charge ahead, you're going to spend a lot of time and a lot of money, and ultimately you're not only going to impact on those 10, but you're going to then start, because of the loss, start eating up other siblings that you hold, if that makes sense. I might not be articulating that exactly, but I guess, at some point you were impacting your other investments, going after, kind of a dead horse.
So let's maybe we talk a little bit about what happens in that scenario at the end of the day, right? So correct me if I'm wrong, Matt, but you don't really know any of this until you get at the end of the redemption period, right? So it hasn't redeemed. Okay, let's move forward with foreclosure. You order a title search, it comes back, and you say, oh, this has got 40 heirs, or in this case, 6 or 7, and the only one noticed at the beginning of this whole process was one by the county, right? So you're saying the sale is essentially overturned automatically. The county says, oh, we screwed up, and what happens? They just give you your money back, no interest?
Yeah, so let me take it one step back. There are sometimes some indicators when you're doing your due diligence where you can catch this on the front end. Mm-hmm. There are some counties that will list the property as heirs of XYZ or care of the estate of XYZ. When you start seeing in the listed names on the tax rolls things like estates or heirs, or family of, that's when you need to kind of take a step back and decide, is this something we want to bid on and put significant resources towards. If you've missed that, or if the county just hasn't listed it, I mean, they're under no obligation to do that, and sometimes they won't. And you get your title search back, and you see you've got a number of different folks that have a potential interest. One thing that we're going to do in South Carolina is we're going to have a guardian ad litem appointed, and we're going to have John Doe and Richard Rowe, unknown parties are going to be named, and we're going to publish service of process in the county, with the thought process being that if we don't know about these heirs that could potentially come out of the woodwork, we want to have a person who is going to represent their interest in front of the court and present to the court that, hey, I separately looked behind Nelson Mullins to see if there is anybody else with an interest. I can't find anybody else. Nobody's contacted me after the publication. And if nobody's going to assert their right to the property, then the court might not set aside the tax sale. Where you've got a situation where people come forward, either they contact the guardian or they appear in the action, the court's kind of balancing two interests. They're balancing, the county can only give notice to people that it knows about, right? So if the deed's not recorded or the will's not recorded and the estate wasn't open, the county doesn't necessarily know that there are 10 other heirs that they need to give notice to, and they certainly don't know their addresses. So the court's going to balance that with not wanting to take somebody's property from them if they truly weren't given notice and given the opportunity to redeem. In South Carolina, fortunately, there's a case that's out there that even if the tax sale is voided by the court, you've got the ability to receive your bid back plus interest. Now, there are, of course, caveats to that and exceptions that might apply, but that might be something you want to look at early, is to do some sort of early settlement that would allow for a late redemption, essentially, and you recover your money from the heirs. Usually the county is going to be immune under sovereign immunity and not going to have to pay you extra money. So your efforts are really best focused on the county and trying to resolve, on the heirs and trying to reach a resolution that way.
Got it. Okay, so it's not automatically that the sale's overturned and you're out. There are options to pursue there. Sorry, Randy.
There are, but you gotta think that the county, if they've got somebody that's coming in from out of state and their choice, the judge's choice is between somebody that's just buying a bunch of properties and somebody who goes to church with them or knows their family because they shop at the same grocery store. You might be on the wrong side of that one.
Yep.
I was going to say, Matt, on the front end, when you're doing due diligence, if there's a client that comes to you and says, look, we've got this situation where it's the estate of or the family of, what would be the factors you look at that say this would still be a property that's worth taking the risk on? Because I think that's an important point. Is it's a worst case scenario if the balancing test does, if you've got a fantastic property, it might be worth taking the risk. But what would how would you lay out the factors to decide whether or not, knowing that on the front end, it's worth it to take that risk, so that you potentially can avoid the risk of taking a huge loss?
Yeah, so we'll look at things like a title search, probably a FOIA to the county for any kind of communications the county has had with the family or the heirs, because if the heirs have come in and explained to the explained to the county that there are a bunch of family members involved here and have provided names or information, well, now the county's on notice that they need to provide a tax sale notice to each of those individuals. So that's something that you got to factor in. But if the county has no notice of these folks, and the title search doesn't show in the state and things like that, well, then you're really just doing a cost benefit as far as the attorney fees, the court fees, and the service of process, publication fees, and whatnot.
Got it.
On average, I guess the last thing, and I don't know the answer off the top of my head, but when you get these heirs properties, how much more expensive do you think those are than just our traditional case?
Yeah, they can double and triple at a minimum, just because it's everybody that you've got to serve is going to be an extra cost. Then you've got attorney time for reviewing to make sure the service process was correct. You got additional postage, you've got the publication. Those fees can add up pretty quick.
And the guardian ad litem, which is another attorney, for those that don't know, you're responsible, when you appoint that guardian ad litem, you're responsible, the court will order that all their fees are paid. So then you have to pay all of their time for the representation of the John Does and Richard Roes as well.
That's right.
So,
That's right.
So we can quickly spiral out of hand, and I think in part 3 we'll talk about some of the things that you can do in the front end to hopefully avoid those worst case, at least that worst case scenario. But let's pivot a little bit. And there's another one that I know pops up really nationwide, but I think it's highlighted in South Carolina more than many states, which is the IRS liens. It's Matt, you mentioned that being something that needs to be looked at in more detail in South Carolina. Can you elaborate on that as well for us?
Yeah. We've had situations where certain counties in South Carolina don't give notice to the IRS if they identify through their title search before the end of the redemption period that the IRS has a notice of federal tax lien. It's a gap. It's a known gap in our South Carolina code. And some counties actually take it upon themselves to send notice because they look at the federal statute and they say that if I don't send notice, then this federal lien is going to survive the tax sale. But other counties say, I only do exactly what state law tells me, and if state law doesn't tell me to send the notice, I don't send it. So you have a situation where the tax sale is completed, you've gotten a tax deed, and now you find out that the IRS has, something, a federal tax lien for, it can be for individual income tax, failure to file, those kind of taxes. It could be for business tax, payroll tax, and those come with a ton of penalties, a lot of interest. And the kicker is you as the owner of the property, since you are not the defaulting taxpayer on the federal taxes, you don't have standing to challenge the amount of those taxes. So if the taxes have been assessed and become a lien based on a failure to file a tax return, then the IRS is just going to estimate what the tax is. And of course, the IRS is going to overestimate what that tax is, and it might very well exceed the value of the property. So you come in, you try to negotiate with the IRS, they're going to tell you, well, you're not the taxpayer. You don't have standing to challenge the amount of the tax. You just need to pay us. Sometimes they'll settle with you and work it out so that you can pay, whatever the amount of equity that's in the property and pay a percentage of that. There's never really an exact amount or an exact formula that they'll do for a settlement. But this is something that it's a county by county thing. I'll give you an example. Horry County, which is the Myrtle Beach area, the Grand Strand, they send notice to the IRS. And in those situations, when you serve the DOJ attorney and the U.S. attorney with the notice of the quiet title action, they just say, yep, send us a copy of the notice and we'll file a disclaimer saying that we don't have an interest in the property anymore. But one of our bigger counties, Charleston, they don't send notice to the IRS, and they're very staunchly adverse to sending notice to the IRS. So the price of a stamp to them really doesn't matter. It's just because the South Carolina state statute doesn't tell them to send notice. So you can end up buying a property that's completely underwater with taxes, federal tax liens that exceed the value of the property.
Now, I've heard, and I don't know if this is right or wrong. Hopefully, you can help dispel this myth, we'll call it, is that if you end up with one and you find all you got to do is wait 120 days and IRS doesn't have a right anymore. Is that true or not true?
Not necessarily true. So the IRS, under the statutes that we're talking about, the federal statutes, do have a 120-day right of redemption, or the right of redemption under state law, whichever is longer. We've attempted in some cases to argue that there's only a 120-day right of redemption, even if the IRS didn't get notice, because of some complexities with South Carolina law. In fact, we're currently waiting on a decision from one of our appellate courts, one of our federal appellate courts, that really is going to flesh out that argument and tell us whether or not that's a valid argument and that's something that's here to stay. We're certainly hopeful that the court would say that as long as you give notice in the quiet title action, then the IRS only has 120 days to redeem. But so far, no court in South Carolina has adopted that. The only case that we've got specifically dealing with IRS liens is a case from like 2008 or 2009, which says that the IRS lien survives the tax sale if the IRS wasn't provided notice.
Okay, so the 120-day thing might be true in some states, but South Carolina doesn't have anything that says that's solid. So it's a buyer beware if you want to try to go that route.
That's right. And in certain states that allow you to send your own notices, well, that's a very easy one to avoid, right? Because you can go in and send your notice to the IRS, and then they've got just the redemption period that's provided by state law, or the 120 days. Or the state statute might say, direct the county official doing the tax sale to send the notice to the IRS. In those cases, generally, you're going to avoid this landmine that's out there. But you got to be careful in states where the county official has the full power to send notice and the exclusive power to send notice. You're kind of at their mercy if they decide not to send the notice to the IRS.
So is it something where the 120 days doesn't start until a notice is sent, or is that 120 days from the time the quiet title, or is that a gray area that there's no solid answer to?
So largely state specific. The federal statute is 26 United States Code 7425, and that statute separates the type of sale into two different types: judicial sales and non-judicial sales. And there's not a lot of case law out there explaining which one is which. But for the case of judicial sales, it's 120 days from being named in the judicial sale, whatever the type of, if it's a tax lien foreclosure or a quiet title action, whatever it is, and the judgment being entered is your trigger for your 120 days. For non-judicial sales under 7425B, the trigger is 120 days from the date of sale. And the IRS regulations define the date of sale in a number of different ways, and it's largely specific to the state and when lien holders or other individuals would be divested of their interest in the property.
Got it. Okay. Well, thank you for the clarification. I think that's something that everybody that IRS is viewed, liens in most states are viewed as, it doesn't come up enough. And if it does, I just wait the 120 days or I just ignore them. The IRS never acts on it. And it's when I do hear that as well, they're not going to act on probably $5,000, but or a house that's only worth $50,000 or less, right? But you get a house, you hit a home run, I guess, if you want to call it that. You end up with a house worth a lot, and it's got several $100,000 with the IRS liens. You can bet they're going to come after at least a portion of that or whatever they can get out of that. And so following the rules is always recommended, right?
That's right. And the IRS doesn't have the same motivations to settle like some other parties do. When you've got private parties who have a finite amount of resources to commit to attorneys and a finite amount of resources to save their home, they're motivated to get a settlement done. The federal government, they'll just wait you out because they're not paying their attorneys by the hour. They're paying them based on their commissions as United States attorneys or assistant U.S. attorneys.
Got it. Well, I'm gonna follow up. Sorry.
Well, I was just going to say real quick is on both of these examples too. It's the front end due diligence, but once like we're talking about getting into the worst case scenario, what happens a lot of times is it from a practical perspective, it puts pressure on the clients because now they're spending more money. And a lot of times they'll ask, hey, we gotta, how do we fix this? How do we fix this? Matt made a good point. In this issue, anytime there's a lack of clarity or a gray area in the law, that then has to be adjudicated, and that takes time and money. So again, from a practical perspective, as you're dealing with these issues and when there isn't clarity, it puts additional strain internally. It puts additional strain. And one of the jokes we have is when they come and they're like, how can we fix this? I was like, well, do you have a time machine? Because if we could go back, but if we don't have a time machine, there's a lot of times there are certain situations, and I think both of these that we've talked about so far are really good illustrations of, there's a lot of things that Matt and I work with and we can fix and we can try to come up with a creative solution. But sometimes you get in these situations where it literally is going to take a significant amount of time in money even to try to get to a creative solution. And so, I think that's one of the things you got to keep in mind. And so during the next segment that we're going to do, as we talk about how to avoid those situations, really, that's where you think, okay, if you put a little bit more out on the front end, then hopefully it will prevent you from falling into these scenarios where you don't have an easy solution to get to a resolution. You're going to expend a significant amount of capital, and you're going to cut into, not only your return on investment on that specific investment, but potentially, it will impact your overall portfolio.
Right. And I think I'll throw up a softball for part 3, which is if folks only knew going into sale which properties had IRS liens or potential IRS liens on them, right? And even if it's an amount, right, and they can make an educated decision based on what that amount might be, but just knowing that would help them at least make that assessment. Is that a good assumption? All right, well, we'll talk about that. Sorry, Matt, go ahead.
It is, but the problem is usually the IRS, and you're not going to be able to call them up and ask them for the number. So right. you're going based just on the public numbers, and those could increase with penalties and interest, but then also could have decreased if there's a payment plan that the taxpayer is in. So usually you want to take the worst number possible and factor that into your cost benefit.
Okay, well, we'll talk.
On a Malibu Barbie dream house, you probably maybe want to pass.
Yep. We'll talk about more on options and on maybe how to identify those properties in part 3 of this series for anybody that wants to keep listening into that part. All right, I want to go through one more example. I know there's plenty more examples we could run through, but for today, I think the other thing that I hear not all the time, but I definitely hear it in South Carolina more often than not, which is, hey, I bought this beautiful piece of vacant property in a gorgeous subdivision, and I think it's going to be worth $200,000, and I bought it for $5,000, and then at the end of this day they get a notification as soon as they take ownership from the HOA saying, congratulations, here's a bill for $50,000. Explain to us why that happens. Why, like, that's a giant landmine. So what's going on there, Matt?
Yeah, so upkeep of those beautiful golf courses on the coast and those pools and the tennis courts, that's not cheap, right? So there are assessments that are paid sometimes to multiple entities. You could be paying to a homeowners association, but you could also be paying to a members club that is covered or covers all of the homeowners in a certain subdivision. In certain states make provisions that would not allow those assessments and things like that to be asserted following a tax sale. But other states have that gray area that Randy was talking about. South Carolina is one of those states. There's not a lot of good guidance on whether or not assessments and fees and things like that accrued before a tax sale can be levied against an owner who's holding under a tax deed. So you could find yourself where you're not only going to pay the $25,000 to $50,000 initiation fee, but then you're going to be paying an annual assessment, both for your time going forward after the tax deed and for your time before you even own the property. So not a lot of good guidance there. Other states, though, do have some statutory language that allows for collection of only a certain amount that would take priority over a county tax lien. And so it's very important that you know what kind of state that you're in, and know if you're buying in some of these resort destinations, that you're looking at things, looking at indications that there's a big golf course or some other amenities that you would have access to, because you got to assume that you're going to have to pay for those.
So those are, is it safe to say HOA liens are essentially superior to tax liens, at least in South Carolina?
Well, I don't know that I'd go so far as to say that they're superior. I would just say that we don't have a statute directly on point, and we don't have a case directly on point that says that those liens are wiped out. We do have a case suggesting that the document that creates those liens, the covenants and restrictions, as we would call them here in South Carolina, that those remain on the land because they run with the land and don't get wiped out by transfer of interest in the property. But then the question is, how about the amounts that are assessed? And that's a little bit more of it's a more complicated question because we don't have direct guidance from one of our appellate courts on that issue. Whereas other states, they do. They've got statutes or court decisions that specifically say it doesn't take priority and it's extinguished by a tax sale. So knowing your jurisdiction is key when you're buying into something that might have some HOA assessments.
But, Matt, even in those situations where, the prior amounts may be, set aside by the issue is, having and going forward. I mean, it's still a significant expenditure. And one of the things that I think is a telltale sign, traditionally when we're looking at these, if you have a significant amount of unimproved properties, a lot of times you're not seeing, well, I guess a lot of the cases I'm thinking of that we've handled have been where they've picked up, 5 to 10 unimproved properties in one of these subdivisions or whatever you want to call it. And I think that right there should be a telltale sign of why, and that's the biggest concern too, in my mind, because even if you say that the prior amounts were extinguished, if you pick up a significant amount of unimproved properties and say that each parcel has a $20,000 annual fee, you're in for $200,000, and at that point that's you're on the hook for.
Mm-hmm.
And so I guess one of the things you could look at is, do you just let it go back to tax sale, Matt? And then again, does that let you off the hook? Does it, because then you're in a position where you're taking the exact opposite position that if you're saying, oh, the previous liens were extinguished, but then you let it go to tax sale, so it's
So it's really two different here. It sounds like they're kind of connected, but one is delinquent HOA fees, and do they stick and hold, and are they the responsible of the new proud owner of that vacant lot? And then you've got the new assessments, as you come into ownership of that lot, the new assessments that it may or may not be assessed, at the day of ownership, right? And they can combine in some cases. So, and it sounds like these amounts are not insignificant. It's not a $500 amount. They can be tens of thousands of dollars per lot. And so knowing which ones come with these assessments or not, I mean, if you're buying, I'll say buying real estate traditionally through a realtor, there's probably requirements for the realtor to divulge that and so forth. There's certainly none of those requirements, by the county through a tax sale to say, hey, this one has a $20,000 HOA assessment. This does not. That's your responsibility, and you need to keep that in mind. Do I understand those two scenarios correctly?
You did, and we'll talk, I guess, in part 3 about some indicators where we can give you some ideas of what to look for before you buy. But one key thing that Randy touched on is that those assessments, even if the HOA takes the position that the prior owner's assessments aren't your responsibility, but you have the going forward responsibility, you can't just get out. I mean, it's truly Hotel California that once you own the property, those assessments are yours, and they're going to come after your entity for them, even if you let it go to another tax sale or convey it to some sort of dummy entity that is defunct or whatever the case might be. There are all kinds of ways that they can come after your entity for amounts that have accrued that initial assessment for the initiation fee and the current assessments, because a lot of those are personal obligations under the covenants and restrictions.
And I think too, one of the important things to think of, if you've got a housing subdivision and you've got a bunch of unimproved lots, then you're going to have a developer who is still actively involved, right? And so they've got a significant amount invested into this. And they're also going to have probably still control over the homeowners association because they still have a significant number of lots. Okay, so as opposed to having somebody just with the homeowners association that's all developed, they may have an interest, they may not have an interest in coming. If you've got a situation where 2/3 of the development is still undeveloped, you've got a development, and a lot of times in South Carolina, some of these developments take off, some of them don't, some of them stall. This is an easy way for that developer to recoup these costs, and they will go after them to the bitter end. Where I think a lot of times when you look at it from a homeowners association standpoint, you know, I mean, if it's 1 lot or 2 lots and you got the homeowners, they may not want to mess with it. You know, it may not be worth it. It's everybody else. It's like our homeowners association in my neighborhood. We've all got jobs most of the time. You know, you don't want to mess with it. It's something on the outside. This is a direct income benefit to the developer that still is holding on to these lots. And so, you know, I think, again, those are the types of things you want to look at. And if it looks too good to be true, wow, look, I can pick all these up. Nobody else is bidding on them. I can get them for nothing. You know, it's probably not a good, you know, opportunity.
Yeah, and while that might differ state to state as far as what can accrue and follow you and your entity, one thing that's not going to differ state to state is in Randy's scenario where you've got the developer who wants that cash and needs it, they can chase you to other states as well and start assessing or attaching, executing on other assets that same entity owns. So there are all kinds of ways that you can protect yourself with something like that. But again, that goes back to what Randy was saying. You got to do that on the front end, setting up different entities and you know, making sure your accounting's right, everything like that. But then also knowing, getting out in front of that kind of issue rather than just saying, oh, well, I only own 2 properties in the county. I don't really care if they take them. Well, it doesn't necessarily end there.
I have a question, maybe, well, I'll ask it and maybe we can answer it next time, or if you guys don't feel comfortable answering it, but would it be accurate to say maybe there are some developers out there that see this as a revenue stream more so than actually building houses? And if you get caught up in that, they know every rule in the book, they know how to come after you, they know where to, you know, how to come after you in other states. This is their job per se. And you inherited more than a headache, you inherited a giant mess in those cases. So it is probably imperative to know when you're buying a vacant lot at a tax sale, and at least in South Carolina, to be a lot more wary of it and do a lot more due diligence than you probably would for vacant lots in other states. Is that accurate? You think that's accurate?
A good way, you know, to answer that is when you look at it. So the taxes weren't paid, went to sale. So that would maybe assume that they weren't paying close attention to it, but then all of a sudden they show back up right away to get those homeowner association fees. So, you know, I mean, you don't know, but I don't think that is you know, a wild or inaccurate assumption. I think that could definitely be a possibility.
Okay. Well, we're going to have a lot of fun in part 3 of this series, really digging into, you know, these are worst case scenarios. How do you hopefully avoid them, you know, from the very beginning? And so we'll talk about that in more detail in the next episode. Thanks everybody for joining me. Thank you, Randy. Thank you, Matt. We'll talk again soon.
Thank you. Take care, everybody.